Same, item number 9, same.
Same, but my lord, he is a post-acquisition purchaser.
Let them consider.
Like consider, and my lord, one thing is that he taking further steps. His status may be considered by the lender whether it is acquired or not.
Lordship, affidavit of service.
হ্যাঁ, ওগুলোতে প্রত্যেকটাতে এফিডেভিট অফ সার্ভিসটা নিয়ে নেবে। What is your deed of conveyance?
Lordship, it is at my lord, page 18, my lord.
ওই ডিড অফ কনভেন্সটা হচ্ছে পেজ 18 থেকে পেজ 18 টু
My lord,
পেজ 18 টু বোধহয়
42. Housing report is at 47.
হ্যাঁ, আর এখানে হচ্ছে কনভেন্স ডেটেডটা হচ্ছে বলে দিচ্ছি তো,
My lord, the 16th December.
16 ডিসেম্বর 2024। এখানে রিট পিটিশনার একজন, হ্যাঁ, আর এখানে তোমার হচ্ছে
Representation
5 কাটা 6 cheaters of land together with
Mahuja Sampa Mirchanagar.
together with uh, a tile-shaded building, tile-shaded building measuring about 100 square feet in Ilar plot number 16,376,578 16,376 and 578 in Khotian number 815
behalf of
He's
the private
appearing on behalf of the private respondent.
I am appearing. 10 and 11.
My lord, I am appearing for the
But
state,
the
my lord, along with my
allegation-
learned senior Mr. Sumitra Bandyopadhyay for the state.
But the allegation is, my lord, the illegal, the quarry and stone extraction is going on in the agricultural land without taking any permission from the government, my lord.
Sure.
My lord, I made a representation before the authorities to look up the matter. The
Where is
whether
the
this
representation, sir?
last page, my lord, kindly see.
My lord, this case is not at all
Page
maintainable.
Page 26, my lord.
Which?
26. But page 26 onward, my lord.
Lordship.
Where the excavation is going on?
Yes, my lord. Kindly see.
No. What is the schedule of the property? What is the nature of the
My
property?
lord, property is the agricultural land. My lord, kindly, I have stated-
Agricultural land of whom?
But the petitioner, also petitioner and other private respondent. But the suit is pending. Well, the status quo order has been granted in favor of the.
You kindly come
parties.
to
Kindly
page
see
17 and 18. 17 and 18.
Page 17, my lord.
Reputation is maintainable, my lord. Already status order is there, private dispute and title suit is pending before the lower court below, status order is there.
Private dispute
And
regarding the
already also they have appointed one
regarding the title,
advocate
but
commissioner for inspection.
Nobody is.
Page
not-
These allegations was made
Page
before the civil court.
No, this is not. But
They cannot take the stand in this before this honorable my lord read court. My lord.
declaration and title is the another thing.
They can
this
take
is
the, my lord,
illegal
advantage before the lower court
activities of the
below.
private
So
respondent.
far as
They are
violation of the
stating-
status quo order, the advocates commission has been engaged by the
my
court below.
representation is separate. My representation, without taking any permission from the government authorities, they are doing the illegal extraction of the stone. This is strictly prohibited by the Act.
My lord, also, my lord, I have
That
got the my
should
lord,
be
report from the police
considered.
authority. My lord, I am submitting the report of the police authority,
I
my
do
lord.
not know why the government is supporting the private respondent to doing the such type of illegalities.
My lord, private respondent is a helpless widow, and one of them,
This is the
and one
issue.
of the respondent is a minor daughter,
Well, only my lord, my
and they are excavating.
submission before your lordship is, my lord, the act is strictly prohibited. They are not permitted to do these illegal activities of the stone extraction. There is no license, no permission, nothing.
Take down. The
The Ministry of Mines, the mining officer, Superintendent Police, Inspector in charge. I have got the report from the inspector in charge. Whereupon it reveals, my lord, at present no mining activities in respect of Blackstone is taking place over the said land.
Let them consider, let
Let the report
their
be,
opinion.
let the report be filed in
हाँ,
the.
ওটা নিয়ে নাও।
ওটা নিয়ে নিই।
ওটা লিখে Which for the petitioner?
This is my lord. Second round of my lord writ petition, my lord. In the first writ petition, my lord, on previous occasion, my lord, the Honorable Justice, my lord, has happened. My lord, kindly have a look to page 133.
Give me a second, sir.
Service.
Any private respondent is there?
Only go. Land acquisition. Page 133 is the previous one.
So compensation has not been disbursed.
My lord, what they have done, my lord, they prepared a, my lord, an award, which is not as per the provisions of the law, because the proceedings was lapsed earlier. But till, my lord, that what they have assumed that this is the admitted amount by them, that even that has not been disbursed. We have challenged the order itself, passed by the competent authority, pursuant to the order of this court.
Before?
By the, my lord, before this honorable court, the order was passed by the assistant secretary as per court's order.
Show
Order
me the previous order. আমাকে
133.
একটু ওই বইটা দাও না, ল্যান্ড অ্যাকুইজিশনের নতুন বইটা চাই আমার। 2013 একটা। Show me the order.
Page 133 is the order of the Honorable High Court passed by Her Ladyship Subhra Ghosh, my lord, on 22nd November 2022. On the basis of this, my lord, the impugned order has been passed.
Where is the order in portion?
My lord will find, my lord, next page. On fourth paragraph, in view of the above, writ petition is
Disposed of.
directing to act in terms of the memo number such and such issued in favor, issued in his favor by the Special Land Acquisition Officer Tumlu,
And they complete the entire proceeding for payment of compensation in favor of the petitioner
2 months.
within 2 months. So it has been disbursed.
It has not been.
Not
My
been
lord,
disbursed.
my lord, kindly have a look to page 131. What was that has been recorded in the order? This is the letter dated, my lord, page 130, my lord. Kindly excuse me. This is the 11th November 2021 letter. That case is, my lord, 8081.
Final estimate amounting to 76 lakhs and was sanctioned by such and such. Accordingly sent to the for placement of fund. So what is the
Difficulty.
quantum of the asset, quantum of the compensation?
2 LA cases were there. My lord, in page 30, my lord will take up page 130 in table bottom.
Huh?
Page 130.
Hmm.
In bottom in the table, my lord.
Yes, sir.
This
Yes.
is LA case number 57 of 1981.
Yes.
My lord, they say, my lord, what they admit, page 31, date of possession 1980,
হ্যাঁ
publication in the official gazette 1988.
আরে বইটা বার করো না, ওই নতুন বইটা 2013 একটা। Yes,
My lord, the
final amount amounting to 6,65,000
my lord,
sent to all original documents.
my lord,
Who
this
are-
is this
You are
is,
an awardee.
yes, we are the awardees.
You are an awardee.
We are the awardees. My lord, we have challenged this award, not only the award, the process, because in 1980, my lord, possession was taken by publication of notice under.
So what is your grievance? Tell me.
grievance is that
It has not been complied with.
not complied with what they have determined, that based on a proceeding of acquisition which has been lapsed. First point. That has not been.
How can it be decided in a read petition?
Yes, it can be decided. There are judgments. I will.
কি আছে আগে বইটা দাও।
Today, what I submit, my lord, what they admits today by the impugned order, let them, my lord, disburse the amount, because, my lord, honorable court earlier,
that is suffer.
subject to,
আমি
my
বলে
lord,
দিই
the-
clearly.
এক minute, subject to result of the
অনেক এত গল্প
petition.
বলার
As I
দরকার
say, my lord, the acquisition proceedings by which our land has been acquired, my lord,
এটা পুরনো বই।
that has been
নতুনটা
lapsed
2013 এক বলছিল।
due to.
আমি দেখবো।
Well, earlier one writ petition was moved before this
Ah.
honorable court by this.
Direction was passed for disbursement of the
So,
compensation.
Milord, your lordship, kindly see the ordering portion. It starts from 133.
Yes, sir.
Page 134, mere operative portion. And in view of the above, the writ petition is disposed of directing the 8th respondent to act in terms of the memo number dated such and such, issued by in his favor by the Special Land Acquisition Officer Tomlu Purbo Mednipur,
Hmm.
and complete the entire proceedings for payment of compensation in favor of the petitioners within 2 months from the date of communication of this order,
হ্যাঁ
upon giving reasonable opportunity of hearing to all the interested persons, including the petitioners and their representatives, in accordance with law. The authority should make all endeavor to pay the compensation by the date upon any intimation to the petitioner
এই লাল বইটা দেখি।
with the aforesaid direction such and such, my lord.
বই না চিনলে আমি কি করে জানবো বুঝবো? এই তো লেখা 2013 এক বলছি।
My lord, and this,
শেষ করি না।
হ্যাঁ then what happened?
বললে বলবে। Well, this was the direction passed by this honorable court.
হ্যাঁ
Pursuant to the direction of this honorable court, my lord, hearing was taken.
হ্যাঁ
But the page 144, your lordship, kindly turn to page 144 of the writ petition.
yes
In connection with the disposal of the honorable high court order dated such and such in Ranjit Maiti and other versus state of West Bengal. The opportunity of hearing was given, my lord. They were present before the authority, and authority, my lord, taken hearing, and after perusing all the documents, my lord, it was the ordering portion, my lord, 147.
yes sir.
As from the report of the special LAO, office number such and such, dated such and such, it is seen that for the LA case number 57 of 1981, a sum of rupees such and such, and for the second LA case number 15191, a sum of rupees such and such were sought from the requiring body. Well, compensation amount was sought from the requiring body.
হ্যাঁ
And in the year 2013 for payment of compensation to the landowners. Hence, it is decided that the LA collector and the requiring body will take necessary actions to pay at the soonest possible. At the soonest possible, those sum together with the further interest until payment, as was admissible in terms of section 7(2) of the Act such and such, as well as section 34 of the Act 1894. The amounts which are 80% of the advance compensation were paid earlier in 1981 and in 1980, respectively, immediately after taking possession of the lands, are to be adjusted with those sums, if not already adjusted with, while calculating those amounts which are requisitioned.
হ্যাঁ
With this decision, the undersigned, the 8th respondent, upon which the order of the Honorable High Court was disposed. My lord, this is the findings of the Special Secretary, Land and Land Reforms Department.
so pay-
I do not measure the whether this is.
no I understand.
If
They
it
are
is not paid, well, let it be paid. Let it be paid.
that is
That
the
is the
grievance.
direction of the Honorable Court.
not the absolute
That is the
grievance,
Honorable
that
Court's
is the
direction.
partial grievance. May I, my lord, now submit, my lord? what they have
Tell me,
decided, yes, my
So
lord.
far,
May I-
LA case number 151 of 1980-81
Hmm.
and LA case number, yes,
57.
57, two cases, my lord.
Two cases.
yes,
My-
57
my-
of 81.
my
Those
record-
were of the those were governed under the Act 1 of 1894.
My lord, no.
Yes, my lord.
Why?
May
That
I-
is
may
the
I-
findings
may
of the special
I- may I
LAO, my lord.
submit, my lord, may I submit, my lord? May I
Huh.
submit? This case was initiated under Act 2 of 1948, that is West Bengal Requisition of Land and Acquisition Act 1948, Act 2 of 1948.
Hmm.
In the Act, my lord, there is provision first, it is other than the Act 1. Act 1 is direct acquisition. Here, my lord, first requisition, thereafter acquisition under Section 4A. In the two cases, in one cases, my lord, we will find acquisition was notice under Section 4A was published in the year 1988.
Just answer to my question.
Yes, my lord.
Can a read court
Yes, my lord. My lord.
make an adjudication with regard to the quantum of
No,
compensation?
not quantum.
Then why are you saying?
Not quantum.
I'm passing a direction to disburse the compensation
yes,
within
my lord.
a-
Yes, my lord.
within a fixed period.
That should be, my lord. My lord, I'm
What
grateful
more I
to your
can
lord.
do?
Can I complete? They are twisting the fact, my lord.
So that
Why I say, my lord?
I'm not misleading the honorable court. He was misleading.
The compensation which has been determined in a proceeding which has been lapsed, I will rely upon the judgments and provisions of the law. This is not the easy, my lord, what they are saying. What I have said, what they admit today, what the compensation had been determined by them under the old act, let it be determined and in pendency of the writ petition, because, my lord, the act says, the 48 act says, my lord, award to be published within 2 years. No award has been passed. My lord, thereafter, my lord, in 1996, certain amendments were enacted under this old act, which permits, my lord, to, my lord, publish an award from 1st April 1994 within 1 year to publish the award by 1995. No award has been passed.
Very good.
So, and this issue, my lord, has been decided by our larger bench, my lord, decided in the case of, my lord.
What is your prayer?
My prayer is today, as on today, what they admits the amount under the old act, let it be disbursed, and what would be the actual amount, because why I say, my lord, the acquisition proceedings already lapsed. So in 2013, whatever the compensation they have assessed, that is not par as the act.
Hmm.
Because in a proceeding which has been lapsed, the acquisition proceeding which has been lapsed, on that proceeding, my lord, in 2013, no award can be passed. Award to be passed in accordance with law. May I submit?
But what is your prayer?
Yes, my lord.
What is your prayer?
Yes, my lord. In accordance with the new act 2013, under the new act,
Place the
by
prayer.
setting aside the,
Place the prayer.
yes, my lord.
Place the entire prayer.
Prayer A, by setting aside the impugned order. My lord will find an interim order I have placed ad hoc basis, prayer F. Ad hoc basis, the compensation determined on ad hoc basis, that would be disbursed. Prayer F I have paid,
Then it is required to be decided on exchange of
Yes,
affidavits.
and in
Yes,
the
my lord.
meantime,
Yes, my lord.
my lord,
If you want to say that the land acquisition is required to be set aside, process has to be set aside
no,
by the
it has-
operation of the law,
it has been already lapsed. On a lapsed proceeding,
I
they
try to
cannot.
understand what I'm saying.
Yes.
Your first fold of submission is that for a direction, rather for an interim direction upon the respondent authorized to pay the amount as has been assessed by them.
As has
And
been
your second
on ad
fold
hoc
of
basis.
submission
on ad hoc basis.
and second fold of submission that to set aside the entire acquisition process.
Not set aside entire acquisition proceeding. Acquisition proceedings which has been already lapsed, it is not required to be set aside. The impugn order that has been passed holding that the compensation.
Then it is required to be adjudicated by you.
Yes, it is required. And my lord,
Take that.
and another thing, my lord, another thing, in the impugned order, they say, my lord, for revival and notice under section 93A and 93B has been issued. But in the proceedings before the competent authority pursuant to the direction of this
Very
honorable court,
After hearing the learned
Well,
one.
Only
because the
one.
cause of action-
Rest
My
of
lord,
the
may I
court is
sub-
to be paid, my lord.
There are judgments in our High Court passed by the division bench.
No, I am not.
When
I'm
cause of
disputing
action
that.
is one, when cause of action is one, court will decide the cause of action in one issue, and the petitioners joined, my lord, because the LA case are the same LA case. Order impugned is one order impugned. So my lord was to decide one
Yeah.
issue.
refer the case,
I will
first
refer.
refer the case, then come.
I will
I'm making it not today. Come tomorrow.
tomorrow may not be perfect. From tomorrow, my lord, I will be in.
Yes.
তাহলে month list of May
My
2025.
lord, next week, my lord, next week.
My lord, your lordship pass the order. In the meantime, they will file their deficit court.
লিখুন।
There is no my lord difficult.
After hearing the
I will-
learned
Advocate তো ওরা approve করতে পারছে। Poor villagers. You are a costly advocate.
My lord, I am appearing on behalf of the petitioner. My lord, at the time of filing, the date was given as 9th April. So why, it may be possible, so why nobody is appearing on behalf of the respondent?
9.
9th.
একটা কাজ কর, let the matter be listed on 9.
কালকে।
ও not today হয়ে যাবে। Not today. হ্যাঁ কেটে কেটে Come with the affidavit of service.
না না একদম না।
I am for the petitioner, my lord.
হ্যাঁ, ওটা নিয়ে নিও। The affidavit of service as filed today on behalf of the writ petitioner is taken on record. Item number 12 দেখি।
Yes, my lord. My application, my lord. My lord, kindly come to page 13, my lord.
Who is for the state?
I am for the state, my lord. I have already got the instruction, in terms of the representation of the petitioner, my lord, already steps has been taken by the assistant engineer relating to the demarcation of the PWD land, my lord. This is the instruction, my lord.
We will complete
And-
the same very soon, my lord.
Yes, my lord. Let it be, my lord, completed.
Page 13 and 14, my lord. My prayer, my lord, for
So in the event it is found that there's an encroachment, he
No,
will
no,
start a
it-
proceeding under section 2.
all,
It must be removed.
লিখুন।
My lord, kindly direct that if there is Lord, I beg to appear.
I'm for the private respondent, my lord, 5 and 6. 7 and 8, my lord.
The state is not appearing.
So is for the state.
My lord.
দাদা দাঁড়াও না।
Then you are for the
Private respondent, 7 and 8.
private respondent.
Matter is very simple.
Matter is not meant.
State is, where is Mr. De? Mr. De and Mr. Mahatha, they are not available.
Your lordship, my lord,
My lord can direct my learned senior.
You are also AGP.
I'm the senior government advocate.
Then you can
Yes,
Your lordship's direction.
Please,
now,
please,
I
please.
cannot be.
my lord,
My lord, this petition is not maintainable, my
my lord,
at all.
whatever may be, my
Yes.
lord, lordship, kindly, my lord, allow me to make my submission. My lord, this is a case, my lord, where,
Where is
my
the,
lord,
where is the letter under challenge?
my lord,
Page number 28.
Page number 28.
number 28.
Page number 28.
Madam, may I,
Lordship, kindly,
madam, may I submit one thing? May I request Mr. Ottobar to appear with me?
Sure, sure.
my lord, lordship, kindly consider there, my lord, page 28, my lord, in the last para. If you
Sir,
posit
sir, your good name is, your good name, Mr.
আমার নাম সৌমিত্র বন্দ্যোপাধ্যায়
সৌমিত্র বন্দ্যোপাধ্যায়।
সৌমিত্র বন্দ্যোপাধ্যায় along with প্রিয়ব্রত পট্টপাল
Mitra Bandyopadhyay, senior government.
advocate. And Mr. Potopal মানে প্রিয়ব্রত পট্টপাল, he is appearing along with me. Just take it, Sudhir. না ওটা বললে হবে না 10-1 10-2 10-2 10-3 যাবে।
You are in government panel.
Yes, my lord, he is here with me in panel.
Sir, what is the difficulty?
My lord,
What is the wrong in issuing a notice?
my lord, lordship,
Nothing is
kindly,
my lord.
lordship, kindly
This
consider.
petition not maintainable at all.
Then, my lord, lordship, kindly allow me, my lord, to make my submission.
Please, please.
My lord, I will not take more than, my lord, 2-3 minutes. My lord, there was an internal dispute in between the petitioner and private respondent.
That is
A
another.
suit,
That
why
is-
you are making your submission?
Yes, yes,
Sir,
Your
sir,
son will come.
please, please.
my lord.
My lord,
Keep some decorum.
my lord, the private respondent filed, my lord, one, my lord, suit for partition. While pending, during the pendency of that suit, their, my lord, interim status quo was there. My lord, they filed a writ petition stating that we have occupied, my lord, PWD land. Now, my lord, that writ petition was disposed of, directing, my lord, by the Honorable Justice, my lord, Rai, my lord, directing the, my lord, BLRO, my lord, lordship, kindly consider that order, my lord, page 21, lordship, kindly, starting from page 21, lordship, kindly, I don't disturb your lordship. The exercise, well, that directed the BLRO to cause an, my lord, inquiry. My lord, the entire exercise has been completed, carried out and completed, page 22, by the jurisdictional BLRO positively within a period of 4 weeks from the date of communication of the order. Thereafter, in the event such a report confirms the alleged encroachment and construction on the PWD land, then the jurisdictional assistant engineer PWD, after issuing a prior hearing notice to at least 7 days to the petitioner and the private respondent, and after giving an opportunity of hearing, shall decide the state representation dated October 1929, 2024, annexure P1 to, at page 20, as referred above by passing a reason order. In this case, what happened? Lordship, kindly consider the inspection was made by the BLRO upon giving, my lord, upon giving notice to all of us. Thereafter, that BLRO Sutahata, my lord, communicated the inquiry report, my lord, which will appear from page 25 to the, my lord, concerned assistant engineer. My lord, thereafter the assistant engineer, my lord, issued this notice for removal. No hearing has been given. My lord, that was the order, hearing. First paragraph of the letter 25. Page number 25, with reference to the above mentioned subject, the undersigned has conducted a field inquiry with assistance of the office of the RI after having notice duly to the respondent and the petitioner. Well, notice, sir. At the time of inquiry, petitioner, respondent, and the PWD, an official of PWD, with some local villagers were present. The following points are necessary to be furnished in this regard. This is the report. That report.
Inquiry was conducted in your.
Lord, I'm not disputing this. Lord, my contention is, Lord, I have twofold submission. Lordship, kindly consider the Honorable Justice Lord Rai, while deciding the matter, directed the PLRO to file the report before the assistant engineer. And the assistant engineer will conduct a hearing within 7 days. That part has not been done here. What has been done by the assistant engineer? He has, my lord, directed my lord, to remove the illegal construction. This is, my lord, am I clear to my lord? My lord, lordship, kindly consider. Below page 22. In the event such report confirms the alleged encroachment and construction on the PWD land, then the jurisdiction assistant engineer PWD, after issuing a prior hearing notice of at least 7 days to the petitioner and the private respondent, and after giving an opportunity of hearing, shall decide the said representation. My lord, that part, my lord, has been overlooked by the, my lord, said assistant engineer, respondent number 3 hearing. My lord, my second contention is that, my lord, if your lordship kindly see the inquiry report as filed by the BLRO, page 27. There the allegation is that I have encroached 2 feet by 31. My lord, it is a big area, and lordship kindly consider a hand sketch map, not to scale. My contention is that I made a representation before the assistant engineer stating everything. My lord, that should be considered by the concerned assistant
Should be
engineer.
in the earlier round of litigation, who is the lead petitioner?
My land
for the
friend.
litigation.
That is why my land friend is shouting.
No, not shouting, not shouting.
My lord, page 20, 30 and 31 and 32. My lord, that is the representation I have made before the assistant engineer. Let assistant engineer consider page 31 and 32. That will be the proper. 31 and 32. There, my lord, I have stated everything. Because, my lord, if your lordship kindly consider, the inquiry report is one. And, my lord, so far the sketch map is concerned, this is not to scale. My lord, it is a hand sketch map.
So according to you, before passing the impugned notice,
Yes,
the assistant engineer should ought to have been given a notice.
yes.
That should be, my lord. As per provision of the law, this is the provision, my lord, I'm to down. 10-1 টা দাও।
Yes, yes, it is.
দাও না, my lord কে বার দাও।
Yes, yes.
Well, that is there,
May I read,
and
my lord?
the order also.
There is no, my lord, order, my lord, there is no, my lord, the illegalities. If 10-1, my lord, I am reading. If any person is found to have made an encroachment on any road, street, pathway, or land which is declared to be highway under subsection 1 of section 3, or makes an encroachment on a highway in contravention of the provision of section 8, or does not remove any encroachment on the expiry or cancellation of any permit granted to him, the highway authority or any officer authorized by him in this behalf shall serve a notice on him requiring him to remove the encroachment and restore the highway to its original condition within a period specified in this notice. My lord, accordingly, the inquiry has been held and it is found the petitioner is the encroacher. And accordingly, last provision, my lord, the highway authority serve a notice, that is page 28 of the writ petition, my lord. If you possesses any legal authority or documentation.
So the hearing matter comes thereafter.
Yes, my lord.
Hearing would be it.
Yeah.
Before hearing, my lord, that
Hearing
would
will
have
be
passed.
given.
Scope is
It
very
is
much there.
Very
সেটা তো আছে
ডাকবে
রাখতে বলো
I am for the eight
Huh?
petitioner, my lord.
হ্যাঁ
In this matter, my lord, I am seeking my lord directions upon the assistant engineer of the PWD to take a decision on my prayer, which has been made 20 February 25, which is annexed here in the state petitions at in page number 15. And that where I prayed before the authority.
what is your service?
Yes, my lord.
Is there any private respondents?
No, there is no private respondent. Only I am seeking permission from the assistant engineer to allow me run my business in the land connected to the government road in terms of the section 8. In the section 8 of the Act 64.
There is a provision for
Provision.
grant of permission.
Yes, yes.
Yes. Permission to make encroachment.
Yes, madam.
What is your prayer?
Page 15 minute, my repetition.
No, sir. This cannot be. You have already encroached.
He's already encroached.
My lord, yes, this is admitted fact. I am not claiming any equity or any advantage of that encroachment. I am seeking the permission as a fresh
Eh,
depositing.
Vacate the land, thereafter make an application. Read section 8.
Yes, I've gone through the section.
No, I have not read. Sir, kindly read, sir.
My lord, I'm sorry, my lord.
Pardon.
Section 8, subsection 2, my lord.
Yes, sir.
The highway authority of or such officer may, having due regard to the safety and convenience of
Sir,
the
read subsection 1 first.
no person shall make any encroachment. That is, my lord, that is different.
You have already encroached.
Yes, on that event, my lord, if the PWD authority decides to evict me, always they can do. I am not on that point, my lord.
So show your equity. You are seeking equity.
I am not seeking.
Show your equity. You vacate the land, make an permission. Thereafter I shall keep.
My lord,
I shall keep it in my some.
I'm not seeking any equity, my lord. I'm not seeking any equity. My application should be treated as a fresh, and in terms of any condition, by depositing any fees if they required to be paid to the government, and I'm ready to pay that amount.
He who seeks equity must come with clean hand. You say that permission may be granted to encroach, but you have already encroached.
My lord, that is the fact which I cannot deny. That is the fact which I cannot deny. But
You have
I am
already
not-
admitted. How can you
but,
deny?
but yes, my lord, but I am not claiming, again I am saying, my lord, at the cost of repetition, my lord, I'm not claiming any equity for that illegal encroachment.
Huh?
I am not claiming any equity for the illegal encroachment. I am approached before the authority with the permission that you authority give him permission as a fresh.
Sorry. The affidavit of service as filed today একজন মোশন এলো কেন?
But I tell you,
Who is for the state?
I'm for the statement led by Mr. Supratim Dhar. Led by Mr.
Mr. Thor.
is engaged in some other court country.
Then what will happen?
But there is a direction of filing a written notes of argument that is not ready, my lord.
I have not sought for written argument.
No, my lord.
Then don't embarrass this court. I'm to hear it afresh.
Yes, my lord. May I tell you, lordship, my lord?
No, Mr. Hod is not there. Initiate a fresh proceeding in terms of the right to fresh promise. Making it not today. Ask Mr. Dhar to remain present tomorrow. No, I'm proper matter. Contempt application Subhash Chandra Banerjee versus Vandana. Oh, Howrah. Again Howrah.
Your Lordship had adjourned this
One
matter.
matter has been done, no?
Your Lordship, that has been
It is another matter.
There is no, this is another matter.
another
There
matter.
is a subsequent development. What happened, my lord, your lordship passed an order. Now, my lord, after passing of your lordship order, my client, my junior advocate, Mr. Bhattacharya, received a mail from the advocate of Mr.
Give me a second. Yes, Mr. Mukherjee.
Your
My
Lordship.
lord, what happened, my lord, after the passing of your lordship's order, but my junior received a mail from Mr. B. Pramanik, wherein, my lord, his name had been addressed, but as appearing council of respondent number 610 to 11. Now, my lord, your lord, challenging the order of the demolition, which has been handed over on the last occasion by Mr. Surekha. Now, my lord, the
Self-demolition. order.
self-demolition.
Yes.
The private respondent filed a writ petition. But as it is a new matter, I then and then asked my junior to send a reply that we have not been instructed by the client new matter. However, my lord, this they moved before this honorable court, honorable coordinate bench, and what I heard, my lord, the honorable coordinate bench, my lord.
You are not a party to that proceeding.
They are party that chose not to appear.
Oh, I don't know, Mr. Sureka.
Yes, I am interested. I am interested.
Anyway.
Absolutely.
Yes, I am interested for my clients.
Yes,
Yes, I am
kindly,
interested.
How
Do not try
can
to
this-
prejudice
how
the court.
can this
Do not try to prejudice the
Don't
court.
shout. Don't shout.
How can this contempt petition, this has not been served upon the server in the Sarthak? How can the private respondent get this contempt petition? But kindly make an inquiry.
Tell me what happened before the
I'm
court.
telling you, Lordship. But Mr. Sureka is saying deliberately I did not appear.
Tell me first what happened in this.
But I tell your lordship, I
in
appear
that-
for the writ
Give me
petition.
a second.
But he,
I'll ask
Mr. Mukherjee was not.
But I will not reply. I will not hear you.
Very well.
When I asked a question to Mr. Mukherjee is supposed to answer. Why are you interrupting?
My lord, I was just indicating.
No
because it
indication is required.
was my writ petition.
Sir,
Very
I
well, my
know
lord, I
the
beg
court is
apology.
not intelligent like you. But don't think that the court is so full as we were thinking.
My lord, that is not the thing. My lord, I
And
beg
once
apology.
again,
My lord, I beg
Your court is not so intelligent like you people. But don't think that the court is so full as you are thinking.
Now, my lord, what happened, my lord? Now, my lord,
What is this? One council is addressing. Why are you giving an?
indicating your
Sir,
lordship. the
please
coordinate
keep
bench
calm.
was ordered
Please
because
keep
Mr.
mum for some time.
Very well.
Mr. Mukherjee.
then and then my junior give a reply that kindly serve a copy. I've been told, my lord, it has been submitted before the another coordinate bench that in spite of service, we choose not to appear because we have no instruction, my lord, coordinate bench granted an interim order of stay. Now, subsequently, my lord, very funny thing, my lord, my client received another copy of memo appeal against the order passed by your lordship on the last occasion. Where your lordship is, kindly see your lordship last order. The last order, my lord, your lordship.
Last order in CPAN or
CPAN.
in the main writ petition?
CPAN.
Last order 18/3/2025.
Absolutely.
Well-
18 March 2025.
Yes.
Now, my lord, this contempt petition, your lordship knows, my lord, anyone can download the copy of the writ petition from the Sarthok. Now, contempt petition I have not served up only upon the contemnant, no other person. Now, my lord, how this contempt petition has been received by my learned friend who is appearing for the writ petitioner and the private action in this matter, he preferred an appeal before the honorable division bench. Ultimately, my lord, no order has been passed in the division bench. They have also preferred an appeal. And my lord, I only praying before, like, I don't know whether it has been leaked from your lordship's court or not. But although, my lord, how can they got this copy, my lord? But this is your lordship domain. Because, my lord, contempt petition is pending.
Server in the server it
No.
is available.
No, absolutely not.
No. So far the order date 18.
Order available, contempt petition can't be.
Convent petition cannot.
Can't be. How can the private respondent got this copy, my lord? I put this question to myself. Because I will file an application because this contempt petition has only been served upon the corporation.
Of course.
No other person, because only the corporation is the party.
Yes.
My entire contempt petition and everything where I've underlined that portion has also been received. I will file appropriate application. For the timing, my lord, we are, as my lord, determination has been changed. We have already taken out an applicant and we will take steps, my lord, in the other proceedings. Kindly adjourn for some time because, my lord, already stay has been granted.
So for the timing, let the matter go out of list.
Yes,
Liberty to mention.
absolutely.
Yes, sir. Now it is your turn.
Your lordship passed an order in this matter. A judgment was passed. Your lordship
In
directed
writ petition.
in the writ petition. My lord, over there, your lordship directed to initiate proceeding under 177
Yes.
of the Howrah Corporation Act. Proceeding was initiated. Order has been passed.
You challenge that.
I
order.
challenged that order. Now, my lord, on the last occasion, when the matter was taken up, your lordship was pleased enough to summon the commissioner of Howrah Corporation. Through the virtual mode, she was available, and your lordship then further made a direction that further report is to be given to your lordship as to the steps taken. Now, my lord, with greatest of respect, when the order was passed under 177, my lord, with the most humbly I submit, my lord, that is a fresh cause of action in respect of my client is concerned.
That Mr. Mukherjee is saying.
But may I just
That Mr. Mukherjee is
that
saying.
order was challenged by my client before the Honorable Coordinate Bench. Now, my lord, Justice Chondo is not available for the last 3 weeks due to some personal reasons. So, although an interim order was passed, my lord, that is not uploaded in the server. Now, my lord, thereafter, challenging your lordship's order in the contempt jurisdiction, my lord, we preferred an appeal before the Honorable Division Bench. Now, the Honorable Division Bench, Justice Boshak was of the opinion, my lord, that since this is under 19(1)(a), so my lord, there is a designated bench for that. We moved before Justice, the Division Bench presided over by Justice Orijit Banerjee, my lord. My lord, Justice Banerjee has released the matter, saying that no, this is not under 19(1)(a), and this will be a regular appeal. Now, my lord, Justice Banerjee is in the circuits. Again, this head order is not
Very
available in
good.
the circuit.
Mr. Mukherjee
But only one-
was prayer.
Only one submission, my lord.
As per
Yes.
request made at the part.
We are
Absolutely,
entering
Mr. Rokma. How can this contempt petition be get by this? I will come. Appropriate application. I will come definitely. Mr. Rokit has done a very Mr.
Mukherjee has
and Mr. Sureka has done a very good thing for us, my lord. I know that.
life, my lord.
No, no,
He's
I
angry
don't
with me
name me.
some other-
I haven't done
Absolutely.
anything.
Absolutely.
Do not
But
name me. I know what you do.
Out of the courtroom.
Don't be personal.
he's-
Don't be personal.
Three of you share
you have
cups of
done, everyone knows. Not you.
Well, Mr. Mukherjee is
Please
angry
don't
with
name me.
something else, my lord.
Please
No,
don't
no.
name me.
Not Mr.
He's,
Sureka. He knows it.
his anger is confined to code number 19. After going to out of code number 19, he will offer a cup of tea to you.
No, he will now offer because
And
next
payment
one
has
month
to
he
be
will
made
not
by
come.
him.
Next
And
1 month
payment
he
has
will
to be
not
made
come.
by him.
My lord, that is the angry, my lord. I couldn't till now. I couldn't give him the card, my lord, of my marriage. That's why he's
Very
angry.
good, very good.
Huh?
17th তো 2 PM এ mark করা আছে। এখন apartment মানে 2 PM mark করা আছে।
So 18 and 19, so I appear for the petitioner
especially on the last occasion. This is the question has cropped up whether when
For the
company,
petitioner.
I am for the petitioner, when the company is in liquidation, whether the writ proceeding can be continued with
Yes,
the
yes, 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 yes.
Lordship, kindly grant me a week's accommodation, Lordship. It was I could not get some judgment of the Honorable Apex Court on this issue, because on the last occasion I submitted some judgment of the Gujarat High Court.
Order for order for.
On behalf of the petitioner,
For the
on
benefit of
behalf of
Mr.
the
Ghosh.
petitioner, accommodation has been paid for. Therefore, accommodation is considered and allowed. Let the matter be listed on May 1, 2020. May 1 এ কি বেশি ম্যাটার রয়েছে? কেউ বোধহয় কিছু ম্যাটার ফিক্স করেছি গো। দেখো তো। এইটিন 19 সেম অর্ডার।
Same order.
Great.
Deep level. কত তারিখ হলো? 6 তারিখ?
6th May.
আচ্ছা। আইবো। Deep level.
Lordship, item number 20, Mr. Sumon Banerjee on behalf of the petitioner, Lordship. Lordship, it is a change brief, Lordship. We need 2 weeks time, Lordship, the
Mr.
filing.
Prasad was appearing.
But it is a change brief. At present, Mr. Sumon Banerjee on behalf of the petitioner.
On various occasions, it has been. देखिए my file now. On various occasions, adjournments have been taken on the ground of Mr. Prasad or something like that.
But at present, petitioner, Mr. Sumon Banerjee received the no objection Bhukalatnama, Lordship.
Very good. But what is your reply?
Reply, Lordship, at least 2 weeks time, because the petitioner deciding in at Malda, Lordship. Kindly, Lordship.
Malda is one night journey, sir. Is Malda so far? Huh?
Lordship, no, Lordship. At least, Lordship, 1 week time. 1 week.
Express at 9:30. Read by 5:30 or 6 o'clock in the morning. I know better than you.
But it's a change brief, Lordship. That's why he is asking.
Lordship, I beg to appear on behalf of the petitioner, my lord.
Who's the other side?
My lord, before that, my lord, I have some very small prayer before your lordship, and I would
Yes.
not trouble your lordship with this application. This application was, the petitioner was a bank employee, my lord, Bank of India, and there was a misappropriation of funds allegation that he's misappropriated 5 lakh rupees from the bank, my lord. For that, one disciplinary proceeding initiated, my lord, and he was he was terminated from the service, my lord. To that, my lord, we have challenged this writ petition, which is before your lordship. We have challenged the disciplinary proceeding. Further to that, my lord, subsequently there was development that the Bank of India has initiated one complaint case. And in that complaint case, the entire proceedings initiated, trial happened, and after that conclusion that he was acquitted from the complaint case, my lord. So before us, my lord, there is two things, my lord. Departmental proceeding has terminated from the service and taken our service benefits and acquittal in the criminal court. So for criminal court, my lord, one writ petition was preferred, my lord, and that is pending before the Honorable Justice Parthasarathi Chatterjee, my lord. That criminal case due to change of the circumstances as well as which will prevail, whether the departmental proceeding
You have
prevail.
been convicted.
No, my lord, I have been acquitted. So acquittal and termination, my lord. I have been found guilty in the departmental proceeding.
So what
and
is the nexus between the departmental proceeding and the acquittal?
the nexus is that, my lord, the departmental proceeding, it is our prayer that the departmental proceeding, there was a lot of latches on that part, and it has not been done according to the procedure it needs to be followed. So procedural lapses we will be showing, as well as when the competent court of law has
No.
lordship.
What is the nexus between the departmental proceeding and the criminal proceeding?
Lordship,
Those are the parallel proceeding having got no interconnection.
no, my lord, but the allegation, entire everything was same on that same set of cause of action. The departmental proceeding has has terminated me from the service. Now I am challenging the departmental proceeding specifically, that the departmental proceeding is bad.
I said, hear it out.
But my lord, that is pending before, my lord, most humbly, my lord, that is pending. And my lord, this matter was taken up before that, my lord, and there was an order, last order is there, my lord. So we have prayed to merge both the petitions so that it can be heard, because the
Appeal and the writ petition.
no, not appeal, my lord. My lord, kindly says the last order. This acquittal order is from the learned court below, not
Understand,
learned
sir.
court below. And
That is an appeal has been preferred before the High Court.
no.
Challenging an order of acquittal.
No. Writ petition is preferred, and in that writ petition, I have said when the learned court below has granted me acquittal, and the same evidence has been taken, and the departmental proceeding is completely bad in law. That plea has been taken in the new writ petition. In the new writ petition,
So this writ petition has become infructuous.
type of infructuous, but the cause of action is still same. And in this writ petition before your lordship, my prayer is,
So you seek an assignment before that court.
lordship, this on the last occasion this has happened, my lord, most humbly, my lord, and the matter was released from the honorable bench, and it was assigned, my lord, to this honorable bench, my lord, right now, my lord. I am most humbly seeking, my lord, if it can
What
be
is the
released.
assignment order?
Lordship, I do not know. On the last occasion, there is an order with your lordship's record, my lord, that the matter was released from the bench, my lord. And subsequently, the new writ petition which is filed, this is the order, my lord. And in that writ petition, the affidavits has been exchanged.
No, what is the writ petition? What is the number of that?
Lordship, this is the new
Dekhi
writ
bolche
petition,
dekhi
and the order has been filed. And pursuant to that, my lord, the affidavits has also been exchanged.
So what do you want to do? That I fail to
Lordship,
understand.
release, most humbly, my lord, release, so that it can be assigned, my lord, to that bench only, the new bench, my lord, the bench which is taking this new
I am an
writ.
advocate for the writ petitioner. Call the next matter.
Matter. During the pendency of the writ petition, the petitioner was allowed to be retired from service unconditionally. Now, my lord, according to pension rule, no departmental proceedings can continue and exist after the retirement of the petitioner from service. So in this case, my lord, I have to file an application in view of the subsequent fact that they cannot proceed against me under the rule 153 rules because this proceeding was started against me. Railway pension rules, my lord, does not
So
permit
for the timing, let the matter go out of list.
go out of list. My lord.
As per request made by Mr. Majumdar, ঠিক আছে দেখো না। You are appearing, sir?
Next one.
কিন্তু অ্যাপিয়ার করছিল।
I beg to appear on behalf of
The petitioners are not represented for ends of justice. This court is not inclined to pass any adverse. নোট করে নিন, শুধু অর্ডার শিটটা করে পাঠিয়ে দেবেন, আমি সই করে আবার পাঠিয়ে দেবো, নাহলে আবার কালকে পাওয়া যাবে না। এই দেখুন, এই ডাকুন তো মেনশনিং ডাকছেন।
Last item is 48. You will also take up the 48, item 48, hearing. 48.
your lordship, Kali, take it next to him, your lordship, any day, your lordship.
You are appearing in which matter?
47, 46, 47. I'm praying for not this week, your lordship.
একটা কাজ করো না, নট দিস উইক অ্যান্ড নট নেক্সট উইক অলসো। 21 এপ্রিল রেখে দাও, দেখে নাও। 21 এপ্রিল ওটা অর্ডার কেটে দিই। Yes, sir.
I am for the 48. 48, sir.
No, let me take the mentioning. Thereafter, I'll take
Well, one application for correction, my lord.
application for correction.
Correction.
tell you, Lordship, what happened.
Correction
My other side is
order by
Justice, my lord, Aniruddha Rai. Now, my lord, yesterday, I tell you, Lordship, my lord, yesterday we expressed your view of your Lordship because this was mentioned was tried to be to make it before your Lordship. But his Lordship candidly opined that until and unless an order passed by your Lordship not to take up this matter for want of or something like that, my lord, his Lordship will not take up this matter. That is the thing, my lord. Yes, my lord, for to be mentioned only. Let it appear to be mentioned if your Lordship.
Yes.
Yes.
Okay,
Okay.
sir.
Lord, upon my mentioning on 1st of April, my lord had directed this group 1 land motion to be listed. My lord, it's not listing. My lord.
Eta.
My lord did
Madam,
mention.
mention করলাম।
This was also mentioned on 1st of April. There's some urgency, my lord. Sorry, my lord. My lord. My lord. 2024 motion, my lord. Some urgency is there, my lord. Grateful, my lord. Grateful.
already practically exhausted. Repeated.
Yes. 48 years before the respondent.
আমাদের তো ইন্ডিকেশন দেওয়া আছে যে
বলছি
convenient for us, my lord. Thanks to your lordship. Thank you, thanks, my lord. আমি জানি না মানে আজকে ফার্স্ট ডে
Lordship, my lord, recalls, my lord, Mr. Roy has, my lord, completed, my lord, his part of the argument. My lord and senior, my lord, was making a submission.
বলুন না
Yeah, senior.
বলুন যোগ্যতার বাইরে গিয়ে
My Lord, National Highways Act, Lordship. National Highways Act, yes. আমি দিচ্ছি যদি না আসে আমারটাই
মাই লর্ড
চেয়ারম্যান টু থাউজেন্ড থার্টিন একটা বার করলেন 2013 একটা সকালবেলা যেটা বার করতে বললেন এইটা আমার কাছে আছে, ওইটা দিয়ে দাও। ন্যাশনাল লাইব্রেরি একটা আছে, ওইটা ফেরত দিয়ে দাও, আমার কাছে আছে, ওইটা আছে ন্যাশনাল। Yes.
My lord, in order to refresh the lordship's memory, the last occasion, my lord, there is the argument of my learned friend whether he is entitled for the first schedule, the interest or the solution part, my lord. Lordship, now my learned friend also relying upon the manual of the guidelines. So lordship, kindly come para 25, page 25 of his writ petition, my lord. Sir.
Page number?
My lord, page 25, para 25.
Yes. Yes.
My lord, the para where my learned friend relying upon that the modalities for adjudication of the benefits under the new act was published wide notification dated 28th December 2017, wherefrom it will appear under clause 4.6 subclause 3 Roman 3 of the said modalities or the guideline that all cases of land acquisition where the awards had not been announced under section 3G of the NH Act till 31st December 2014 or where such awards had been announced but compensation had not been paid in respect of the majority of the land holdings under acquisition, my lord. Here, my lord, the two words is important. They are under acquisition as well as, lordship, the word majority. As on 31st December 2014, the compensation would be payable in accordance with the first schedule of the Right to Fair Compensation Act as per the Act. Now, my lord, the coordinate bench order, where my learned friend on the last occasion also relied upon, page 355, my lord, where also lordship three 55, my lord, start from 354. Subsequently, a notification was issued by the Ministry of Road Transport and Highways, Government of India on 20th, my lord, the same thing has been mentioned, that in case of the land acquisition, where award has not been announced under section 3G of the Act of 1956 till 31st December 2014, or where such award had been announced, but compensation not paid in respect of the majority of the land holdings. My lord, where they not paid in respect of the majority of the land holdings under acquisition as on 31st December 2014, the compensation would be payable in accordance with the first schedule of the right to fair compensation. Where lordship, that cut-off date has been mentioned, that is 31st December 2014. If, my lord, the compensation paid, my lord, then the first
determination of the award is 31st March 2015.
My lord, the cut-off date is, my lord, 31st December 2014. If the compensation paid on or before.
No, here award has not been under till 3 years, then it is 31st December.
My lord, here it has not been paid. Well, if paid, then he is not entitled, my lord.
No.
Well, that is our case, lord. He is not, but the compensation in respect of the majority, my lord, my learned friends, Mauza is Itla. And it is an admitted fact, my lord, the compensation has been paid after. But the total acquisition comes for the total 78 Mauzas, not for one Mauza.
So it is to be interpreted whether the majority of the landholding under acquisition shall be restricted to the entire land acquisition process, or in respect of the Mauja in.
No, entire land acquisition. Lordship, we acquired the land for the highways, lordship. We acquired the land in between, my lord.
Only one.
No, not now.
I'm not disturbing whether any Mauja granted this benefit under the right to fair compensation act.
Let me see.
That only thing she was.
They have to show.
That no Mauja,
My lord,
this benefit has been given.
My lord, here, my lord, as per the section 3A and 3D, my lord, we mentioned the total acquisition of the land from 1 kilometer to such and such kilometer. Within these kilometers, my lord, several Maujas are come. Several villages are come, my lord. We are, lordship, their acquisition on respect of that, majority of that. Not again.
So that you have disbursed compensation in respect of most of the Maujas under covered under acquisition.
In my report, my lord. In my report, my lord, kindly come. My lord, kindly come to page 33 of my report.
Page 33
of my report, my lord. The list of the Mausas acquired under the NH Act 1956 for 4-laning of NH 34 in the district of Nodia, wide notification under section 3A of the said act published in the Gazette of India bearing number such and such, my lord, bearing number dated 4th December 2009. In this date, my lord, the entire acquisition has been done, and the ASO number 286 of dated 8th February 2010, that is 3D. And the details of payment thereof, my lord, that has been mentioned in the entire details. Total 78 Mausas, lordship, has been mentioned in page 33 and 34. My lord, the right-hand portion, lordship, the remarks has been mentioned. Compensation paid before 31st December, lordship.
Before Sir March and after Sir leave.
Yes, my lord. If my lord, in totality, my lord, if my lord will see that total 57 Mausa has been paid before the cut-off date. Out of 78, my lord. So the majority portion, lordship, before the cut-off date. So in respect of the majority under the land acquisition, because this acquisition total 78 Moses.
So therefore the applicability of the first schedule of the 2013
It's
will
not
not
applicable. It's not arise, my lord, and it has been mentioned in my paragraph, my lord, page 20, page 10 of para 21.
Yes.
Page 10, para 21. It is submitted that on perusal of the above cited manuals of the guidelines of land acquisition for national highways issued by the Ministry of Road Transport and Highways, Government of India, wide such and such dated, the details of payment of compensation of 78 number of Mousas, within bracket villages, including the subject Mousa, Itla, which have been acquired through the notification under section 3A and 3D of the year 2009 and 2010. The compensation for majority of the Mousas of villages, that is 57 out of 78, that is majority of the land holdings under acquisition, has been announced under section 3G1 of the NH Act 1956 before the cutoff date of 1st January 2015. And also the compensation in respect of such majority of the Mousas, that is the majority of the land holdings under acquisition, has been paid to the land losers before the cutoff date of 1st January 2015. And as such, the benefits of Right to Fair Compensation Act 2013 is not applicable to the subject acquisition, including Mousa Itla, concerning the writ petitioners. Since Lordship, the entire acquisition has been done, the total acquisition of 78 Mousas, out of 78 Mousas, my lord, 57 Mousas compensations has already been paid. In spite of the fact, Lordship, the petitioner's Mousa is Itla, Lordship, because of the majority, as per this manual guidelines, my lord, the entire acquisition, these 78 Mousa, Lordship, come within the umbrella of the entire acquisitions. This is my submission.
No, Mr. They will.
I'll give.
You will give joint.
So, but the answer which I am seeking, my lord, that was not been given by learned friend. Whether any of the Mouja, this benefit was given to not.
No.
My lord, can you record this?
Yes.
না একটু রেকর্ড করবে কেন আপনি আমি বলি তারপর একবার রেকর্ড করবে মাইলর তুমি বলবে তো বাবা আপনার
আমি
yes my lord. My lord, first of all, I am, my lord, on the point of, my lord, statutory provision. What is the statutory provision and how much an advocate can go into that statutory provision? My lord, if your lordship will come, that is the statutory provision of 3G1. If your lordship will come 3G1.
Sir, ultra-virus declare করে দিয়েছে।
কবে কবে দিয়েছে দাও
April।
দাও ওটা দেখিনি তো পরে ওটা দেখে নেব।
This 3G has been already been declared ultra-virus by the Punjab and Haryana High Court, delivered on 20th March 2025.
সুপ্রিম কোর্ট নয় তো?
Now here, argument that
বলছে
আপনি আর্গুমেন্টটা করুন।
হ্যাঁ
হ্যাঁ আপনি করে দিন।
বাবা আর্গুমেন্ট করি তারপরে
আপনি 3G নিয়ে বলছেন আমি বলে দেবেন। It is my duty to point it out.
না না দাঁড়াও। My lord, if your lordship will come to 3G. My lord, first, my lord, 3G1. Where any land is acquired under this act, there shall be paid an amount which shall be determined by an order of competent authority. That is, competent authority means, my lord, Kala, CA, competent authority, and my lord, LA, that is land acquisition. Competent authority appointed by the central government according to the provision of, my lord, National Highways Act. That is Kala, my lord. My learned friend wanting to twist this, my lord. That is 3G. In his argument, my lord, when completed his argument, he wanted to twist it. That whether 3G means that is only Kala 3G1 or
including 3G5. I say, my lord, it is restricted only, my lord, 3G1. That is a specific language is there. That is Kala, my lord. That is the competent authority of land acquisition. That is appointed by the central government. That is, my lord, 3G1. Now, my lord, 3G5. After that, my lord, if anybody, my lord, wanted to, my lord, aggrieved by that, then, my lord, 3G5 comes. I may not want to 3G2, 3, 4. That is the internal, my lord. That is how 3G5, my lord, he must come.
Arbitration.
Yes, my lord. If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government. That is also
been
he
done
can
in this
file.
case.
In this case, my lord, that was done.
He has not challenged the arbitration.
No, my lord. Now, my lord, what is his procedure if he wants to do so? That is 3G6, my lord. After that, if anybody wants to go forward, he must come with 6. For that, the restriction, my lord, that is the statutory restriction, that you must file an application and subject to the provision of this act, that is section 34 of the Conciliation of Arbitration Act 1996. You must go there before the district court, my lord, jurisdictional district court. That is the restriction.
Yes.
And, my lord, if your lordship will, in comments in this act, my lord, if your lordship will go through the comments of this land acquisition portion, my lord, that is the land acquisition by National Highway Authority.
Where from I will get?
What is the definition?
That is একটু তোমার এটা আমাকে দাও, একটু দেন না দাদা। না না না, তুমি আমাকে এটা দাও। 3G দিচ্ছি আমি। 3G টা বের করতে বললাম, তোমার এতে নেই, তোমার এতে কমেন্টস নেই। My lord, if your lordship last portion, my lord, if your lordship go through, I may not want to. ঠিক আছে, ছেড়ে দাও।
When the land is acquired under this act, the competent authority shall determine the amount which shall be payable to the landowners in accordance with the principles contained in subsection 7. 37. 20% may approach the arbitrary appointed by the secretary in accordance with
Now, my lord, I am coming. That is, my lord, restriction. What that is, my lord, he always, my lord, try to submit before the honorable court that I am not challenging the award. That if he wants to challenge the restriction clause, that is 3G6, my lord, that is the restriction clause, he was under that obligation to go to the, for that reason, my lord, he said, my learned friend, my lord, submitted in every court that I am not
challenging
the award, but I am only wanted the money according to the provision of new act, the Act 13. For that is, my lord, your lordship on the previous occasion, my lord, asked my learned friend, my lord, whether the order of the coordinate bench restricted us, as we have not already filed any appeal or anything else, that is, go against us or not. So, my lord, I must come on that point. My lord, if your lordship will come, the order.
$355 or something.
Yes, my lord, 354 starts. My lord, I go through everything, my lord, every
give me a second.
portion. As because, my lord, everything is why I am not, my lord, filing any appeal against that order. Supplementary affidavit submitted on behalf of the petitioner is taken on record. None appears on the for the state respondent. No accommodation had learned counsel for the petitioners and the National Highways Authority. Learned counsel for the petitioners submits that being aggrieved by the award declared in favor of the petitioner under section 3G1 of the National Highways Act 1956, the petitioner submitted an application under section 3G5 of the Act of 1956 before the learned arbitrator, which were dealt with and disposed of by the learned arbitrator by enhancing the compensation payable to the petitioner by an order dated passed on 18 January 2016, which was subsequently modified on 30th June of 2016. That is, my lord, that is Kala compensation of the first 3G1 and 3G5 has done. After that, my lord, now, my lord, subsequently, a notification was issued. Yes. For that reason, my lord, that is a cause of action arose for this. A notification was issued by the Ministry of Road Transport and Highways, Government of West Bengal, Government of India on 20 December 2017 of and clause 4.63 C of the notification records that in case of land acquisition where my lord, that is my lord clearly showed this. Land acquisition where award has not been announced under section 3G of the Act of 1956 till 31st December 2014, or where, my lord, that is 3G, as my learned friend wanted to ventilate 3G, means 3G1 and 3G5. Only for that reason, my lord. 3G of that of December, and where such award has been announced, but compensation not paid in respect of majority of landholdings. My lord, also in that view, majority of landholdings under acquisition as on 31st December 2014, that is the cut-off date. The compensation would be payable in accordance with the first schedule. If that was not done, then, my lord, he will get the compensation according to the first schedule of the land. That is solatium and all the things, my lord. That is, I am not going into that position. Yes. I am not going into that, my lord. Before that, my lord, I want to submit before your lordship that he has not any authority. He has not get anything. This is a restriction clause, my lord. Yes. It is also a restriction clause. My lord took that restriction clause. In view of such notification, the petitioner seek to submit a representation. My lord was not given any, my lord, direction to file a representation. In view of such notification, the petitioner seek to submit a representation before the concerned authority claiming compensation in terms of the notification under the Act of 2013 and pray for a direction upon the authority to consider and represent at the earliest. That is his prayer, my lord. It is a fact that the petitioner participated in the arbitral proceedings when were granted enhanced compensation by the learned arbitrator. The petitioner do not seek to challenge the arbitral award. That is the, my lord, ambiguity comes. The petitioner do not seek to challenge the arbitral award and claim statutory relief in terms of the notification as well as the Act of 2013. My lord, now, my lord, my learned, the Honorable Justice, my lord, that is the coordinate bench, my lord, after consideration of the submission made on behalf of the parties, this court is inclined to hold that since notification dated 28 December 2017 was issued subsequent to the arbitral award, the petitioner are entitled to the statutory relief granted by the notification under this Act. My lord, if that portion is the last portion, then I have no case, man. I have no case. But, my lord, this is not the last portion. This is not the ending. But, my lord, with the Honorable Court, what have you done? Pass the order. That is, my lord, give us in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the second respondent within 15 days from the date. Now, the second respondent is directed to consider, my lord, please consider and dispose of the representation within 2 months from the date of receipt thereof, affording reasonable opportunity of hearing to all the interested parties, including the petitioners, in accordance with law. That portion, my lord, have gone away. Previous paragraph, my lord, completely
has become nugatory because of this point.
Yes, my lord.
And otherwise, according to you, Mr. Te, the coordinate bench would have directed the authorities to disburse pension in accordance with the first schedule of that.
Yes, my lord.
That is your content.
Yes, my lord. But that is, my lord, give us liberty that you must in accordance with law. Not, my lord, that you must comply as for my lord. That
I is also not claiming.
No. My lord, your lordship.
This writ petition has not been filed for implementation of the earlier order. It is the case of the Mr. Rai, so far I can recollect, that in view of the subsequent notification, he is entitled to enhanced compensation in terms of the first schedule of the Act of 2013. I believe that is his case.
But my lord, your lordship asked my learned friend a question, why on showing that portion, that why you are not filing this appeal, how you overcome. তুমি বসো একটু বসো পরে বলো না আমার my lord, for that reason, my lord was not that in terms of our, you pass the order, my lord, always we have seen, my lord, that my lord, when pass the order, seen in terms of our, in compliance of our direction of the order. Now, my lord, here,
yes,
here, my lord, in accordance with law, give us liberty that you must go in accordance with the provision of law, not within the purview of this, my lord, case. The decision taken by the authorities shall be communicated to the petitioner within a week thereafter. In the event of representation is decided in favor of the petitioner, the concerned authority directed to take necessary consequential steps thereto within a month thereto. Again, my lord, a liberty given. In the event the representation is decided in favor of the petitioner, then, my lord, the concerned authority is directed to take necessary action. If that is go against him, nothing would be done. There is also, my lord, given us a liberty. That paragraph also, my lord. Thus, the observation of the direction of the author is disposed of. Now, my lord, I am coming. My lord, he challenged the order of that representation, which was passed by our officer.
Page 359.
Yes, my lord, 359. That is, my lord, I am coming, my lord, 359. That is. My lord, I am coming the third paragraph, first, second, third, fourth, fifth paragraph, my lord. Fifth paragraph, page 359.
Yes, sir.
It is evident that the petitioner in his representation prayed for reassessment of compensation as per provision of the right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act was 2013. National Highway Act, in his statement in defense, stated that it is submitted that accordingly, as per the above guidelines, the provision of new Act 2013 is not.
Yes.
Acquisition in 2013 is not applicable to the subject acquisition, including the for Mouja. Itla concerning the petitioner claimants as the awards in respect of the majority of the landholding as stated above has been announced under section 3G of the NH Act 1956 before the cut-off date, that is 1/1/2015, and even the compensation in respect of the majority of landholdings under acquisition has been paid before the cut-off date 1/1. As the Honorable Court has been pleased to direct the undersigned to dispose of the representation filed by the petitioner, undersigned has taken up the representation and the petitioner deciding the same in accordance with law. For the purpose of building widening, my lord, I am now coming, my lord. Now, my lord, that is 364, my lord. By now, it is also settled position that the first, second, and third schedule of the Act 13 are applicable of the National Highway Act 1956 with effect from 1/1/2015. As such, the following clarified. All cases of land acquisition where the awards had not been announced under section 3G of the Act till ato, and where such award has been announced but compensation had not been paid in respect of the majority of the, that is my learned friend, my lord, that is said the compensation would be payable in accordance with the provision if that was not done. In cases where the land acquisition process was initiated, an award of compensation under section 3G had also been announced before 1/1/2015, but the full amount of award has not been deposited by the acquiring agency with the CALA, the compensation amount would be liable to be determined in accordance with the provisional. My lord, third C, my lord, is in cases where the process of acquisition of land stood completed. My lord, this is very important, my lord. Award under section 3G announced by CALA. Well, that is also, my lord, very important. That is not 3G means, my lord, 3G1, not 3G 1 and 5 or 6. 3G means, my lord, cut off that restricted for, my lord, 3G1, not entire 3G. 3G1, 3G5, 3G6. Cut off date, my lord, restricted only for 3G1. That is this paragraph, my lord, that is the if your lordship.
No, 3G1 does not prescribe any cut-off date.
Yes, my lord, that is the, no. 3G1 cut-off that date, my lord, they within before that date, CALA must pass the award and pay the amount, majority of holdings. In this case, my lord, if your lordship will see, I read the same, my lord. My lord, if your lord, that is your lordship will clear, my lord. In cases where the process of acquisition of land stood completed, how? Award under section 3G announced by CALA. That is competent authority. That is the 3G1. Amount deposited by the acquiring agency. Amount must be deposited by the acquiring authority, that is my learned friend, with the CALA, and compensation paid to the landowners in the respect of majority of the land under acquisition as on or before 31/12/2014. The process would be deemed to have been completed and settled. Such cases would not be reopened. There is a specific abatement, my lord. See, my lord. Now, my lord, 365. For that reason, my lord, my learned friend said, my lord, our officers should go to the jail. If I say, ভাই তুমি এবার থামো, আমাকে বলতে দাও। তুমি বলেছো যা ভাই আমি তো my lord কে বলছি। Now, my lord, on perusal of the factual report of special LAO, Nodia, it is evident that out of the total 78 Moujaz, total 78 Moujaz was, my lord, notification was issued, which have been acquired through the same notification under section 3A of the National Highway Act of the year 2009 and 10. Compensation of majority of the Moujaz, not only majority of Moujaz, my lord, there is a bracket, majority of the land holdings under acquisition. My lord, that is majority of the land holdings of the under acquisition. That is the person who is land loser. Was announced under section 3G1 of the NH Act before the cut-off date, that is 1/1/2015. And also the compensation in respect of such majority of Moujaz, that is majority of the land holdings under acquisition, was paid to the land loser before the cut-off date, that is 1/1/2015. And in the light of these facts and findings, it is clear that the demand for higher compensation is not admissible under Act 2013 for the said Moujaz, including these Mouja which have been acquired through same proceeding, initiated by publication of notification under section 3A of National Highway Act by notification number Ato and Ato, dated Ato of the National Highway Act 1956. Further, on examination, it appears that competent authority, Land Acquisition Kala, has duly assessed quantum compensation of Ato. Furthermore, being aggrieved with the Ato Kala, the land loser of the subject land, it will file application for enhancement of compensation as per provision of National Highway Act, and learned arbitrator enhanced the compensation or arbitral award was passed on Ato. And this enhanced rate was applicable to all the land loser of the Moujaz for reason as cited. Thus, it was, my lord, included.
So, the main contention is that whether in respect of the majority of
landholding,
it is restricted to the entire land acquisition process, or in respect of a particular Mouja. That is the
no, my lord, entire Moujaz, entire 78 Moujaz. That is a language. That is not my view, my lord. That is the language.
That is majority of the land holdings under acquisition.
My lord, that is the language of the sea. In cases where the process of acquisition land stood completed, award under section 3G announced by Kala, that is 3G1, amount deposited by the acquiring agency with the Kala and compensation paid to the land owners in respect of the majority of the land under acquisition as on before the Ato, that is 31/12 Ato, the process would be deemed to have been completed and settled. Such cases would not be reopened. Majority of Moujaz and majority of landholdings. Landholdings means land lodgers, those who are the actual land lodger. That is in this case, my lord, that is land holding. They are defined as land holding. And my lord, 3G1 is the Kala, not 3G5 or 3G6. And restriction clause is there, my lord. That is, nobody can file any application before the Honorable High Court, my lord. He must go to the, if any, my lord, dispute on anything else, if he wants to say something, my lord, he must go to the arbitration court, my lord. That is my submission, my lord.
Can you reply on the point of law?
Yes. Not only I have to deal with the misleading statement made by the councils.
Hey, thou. Hey, thou. Hey, eta dile na amake? এই ওটা কি কে দিল?
জাজমেন্টে দেয়নি, জাজমেন্ট আছে।
জাজমেন্ট আমাকে দাও।
দেয়া হলো তো, দিলাম যে।
না না না, ও আবার ফেরত দিলাম।
কাকে ফেরত?
ছবি তোলার পরে ফেরত দিয়েছি।
Which judgment, sir?
No, বলো that is our internal.
No,
I am
that is
not.
the judgment delivered by Punjab and Haryana High Court declaring 3G and 3 as ultra vires.
3G না 3J?
3G.
3G.
ও সব
Whether, my lord, that judgment has been preferred an appeal or not, my lord, that will not know.
আরে ওসব নিয়ে এখন
Yes.
ও তো ওসব নিয়ে এখন
Not persuasive, subject to question, my lord, when the law declared us by the another high court to be ultra vires, to what extent, my lord, it can be continued by the other high court. That I am not placing the same. I need
Very
not.
good. Very good. Anyway, what is the
First
reply?
submission made by my learned friend that none of the Mojas granted this benefit under section under 2013 Act in respect of any of the Moja which is the subject matter of acquisition under this notification. That was the submission made. Out of which, my lord, kindly consider the Rakna.
No, it was their submission.
It is their
that-
submission.
It was their submission. So far, I have understood that in respect of the
Majority landholding.
majority landowner
So therefore, my lord, can you turn to page 362,
of the writ petition.
writ petition, their order.
Yes.
362.
Yes.
The award.
Yes. There is, lordship will find 78 Mojas are there. According to my learned friend's submission, that 78 Mojas, majority of the landholdings has been, Mojas has been declared, payment has been made. Accordingly, none of this Moja was allotted or provided any compensation under the new act.
Mala, it is not according to me, Mala, it is according to the manuals. According to manuals, that is the made regarding the
Let him submit.
Yes.
No, that is why Malad has specifically argued whether he said that no Mojas is granted this 2013 Act benefit.
No. What they have submitted
I'm
on
unable
the
to
basis
understand,
of the
Malad.
report.
I must be convinced you very
On
lucky.
the basis of the report, that in respect of the land acquisition proceeding, most of the mojas and in bracket
78.
most of the mojas
majority of landholding
and majority of landholding have been awarded compensation
prior
to the cut-off date of 1/1/2015.
Therefore, the Mojas are the other
in respect of it cannot be
segregated.
It cannot be construed that since in respect of Itla Moja, compensation has not been paid to majority of those Mojas, you will not get benefit of that. I believe it is your submission.
Grateful to your lordship. So therefore, my lord, 362. That's specifically I am inviting your lordship. 362.
This is of what?
The award portion, my lord.
362.
Yes.
362 is the order under challenge.
Yes. List of Mojas. 31. Serial number 31.
Just a minute, sir. 362. Yes.
My lord, may I be permitted to take leave, my lord?
Yes.
362. So, I want to tell us, can you keep it that Ranaghat Moja? Can you record this Ranaghat Moja? Keeping apart any other Mojas also. So, according to my learned friend, any benefit because all the majority of landholdings under the said land acquisition case has been money has disbursed, majority of the land cases, and the CG award was declared, assuming. Ranaghat, so it comes within the purview of Ranaghat also. Ranaghat, one of the said Moja. So amongst the 78, it is a specific submission made before your lordship that no Moja under this compensation got any benefit under 2013 Act.
It was not submitted so.
Then, my lord,
So it was not submitted so. It was submitted on the basis of the report.
that is the
That
report.
in respect of the land acquisition proceeding, since in respect of most of the mojas, compensation has been delivered,
therefore, my lord,
compensation has been disbursed prior to the cut-off date. You are not entitled to get benefit of the first schedule of the 2013 Act. It was submitted.
So they are out of this, which the statement made by my learned friends before your lordship, that anybody under this 78 moja are not entitled to get any benefit under 2013 Act.
No, that was not submitted, madam.
Then what? Subject to
That was
correction,
not
my lord.
submitted.
That, my lord, that how I can be segregated? I put this question to myself. I am one of the moja. Can I explain?
It is the specific contention that pursuant to the guideline, on a particular date, most of the mojas have been, or most of the awardees of the various mojas under the land acquisition proceeding, compensation has been disbursed prior to the cut-off date. That was the case.
That is why
You are not entitled.
I am not entitled. So therefore,
This case.
that is what the specific submission. So these are the, what are the mojas? That has been recorded.
I cannot follow Mr. Roy. What is
Yes.
your submission?
I also can follow my learned friend also in this aspect. 78 mojas are there. 78 moja under the land acquisition according to my learned friend. Giving aside all the statutory provision.
For my submission, Lordship, my learned friend already harping, Lordship, according to learned friend, Lordship, it is according to the manuals. According to the manuals, my lord. It is not according to it is not my personal prerogative.
Awardটা declarable হতে compensation দিচ্ছে। স্যার 78 mojas according to the manual statute. Now, my lord, I am rectifying myself. Statute, majority of the landholding comprised of 78 mojas, majority award declared, and majority landholding compensation has been paid. So, in view of the same, none of the mojas are entitled to any further compensation under the 2013 Act. If you logically consider the language, that is the, otherwise my lord cannot segregate. If there are 78 mojas, out of which I have similarly placed with another moja, for the hypothetical, I cannot be termed to be segregated on the ground that majority of the mojas of the say acquisition, majority of landholding money was paid, so you are not entitled to get any benefit under 2013 Act. So, but the similarly stated another moja, whether such benefit has been given, stating that no award has been declared prior to 2030, 1st January 2050, so you are entitled to get 2013 Act. Both the mojas under the same land acquisition.
Your question comes under Article 14 of the Constitution of India.
Apart from that, I am satisfied, Your Lordship, their own conduct. Why I am saying this? I'll coming. So the state, that is why, my lord, can you consider on perusal of the factual? I am on the basis of that, why I am saying that this is nothing but a malicious act on the part of the
Very good, I understand.
Page
That in
365. Page 365. What is the premises? 365. What is the premises? My lord, can you consider? What is the premises?
65 or 365?
365. On perusal of the factual report, such and such, it is evident out of total 78 mojas which have been acquired through the same notification 3A, which includes Ranaghat. My lord, I have specifically mentioned Ranaghat.
Yes.
Act of the year 2019. Compensation of majority of the mojas was announced under section 3G1 before the cut-off date, and also the compensation is for such majority of the mojas was paid to the land losers before the cut-off date. And in the light of these facts and findings, it is clear demand of higher compensation is not admissible under the Act of 2013. So it is just stand that any of the mojas, because these are 78 mojas.
It is the stand.
Now Ranaghat comes within the purview of 78. That is 31.
Page number?
Page number 362.
Yes, 30
Serial number 31.
Yes.
This is the arbitration award. ঘাটিগাছা আছে আর রানাঘাট আছে একসঙ্গে আছে আর রানাঘাট ইয়েস স্যার হ্যাঁ ঘাটিগাছা এখানে আছে ঘাটিগাছা হচ্ছে ইয়েস ইয়ে নাম্বার বল হ্যাঁ ইয়েটাও আছে ঠিক আছে এটা বার করো এটা নিয়ে আয়। তো এই যে 51 মাইনর ক্যালি কনসিডার সিরিয়াল নাম্বার 51 পেজ 363 দে
361.
Yes.
Hmm.
363. Serial 51.
Gotigacha.
Gotigacha. Probably my learned friend will not dispute this arbitral award, which was passed in the 2017. It is Joshua Din.
No, that is not the part of the affidavit.
Exactly.
I'll look into that.
A document which is
My lord, that document has been grateful to your lordship.
Mr. Rai, this is not a part of the affidavit.
Allow me, lordship, to go through these documents, lordship. Allow me to file an exception on this.
Mr. Rai, you cannot rely upon it, which is beyond affidavit.
That is why, my lord, if that be so, my lord, a misleading statement has been made.
My lord, my humble submission
That
before
is
your
the
lordship, my lord, on the last occasion, my learned friend did not intend to file any exceptions.
It cannot be looked into.
Record that the arbitral award, which is not part. This is the arbitral award by them. It is another moja saying that the payment was made or the
Right, it is not your case that you are aggrieved with the award.
No,
your case is that as per the guideline you are entitled to enhanced compensation as per the first schedule of the 2013 Act. Am I correct? So you have to satisfy that you come under the purview of that. That is the case. Mr. Rai, please confine your argument on the law points, sir, because you have argued purely on facts as well as on law on the earlier occasion. If there is anything on the point of law, you please indicate. I cannot allow you to reopen the facts, sir.
Can you turn to page 364 for the sake of argument, the points of law.
Yes.
I'm reading that portion.
Yes.
A. All cases of land, my lord, can you record that? Acquisition where the awards is 3G1. Am I clear to your lordship?
Yes, sir.
Had not been announced under section 3G of the National Highway Act till 31st December 2014.
Not your case.
My award was not declared under 3G1 prior to 31st December 2014. Or where such award has been announced, but compensation has not been paid in respect of the majority of land holdings. My lord, can you consider the fallacy, the word fallacy has been used is that the declaration of award, not the payment of compensation. The declaration of award is the sign on for the purpose of ascertaining the determination of compensation or entitlement of the compensation.
No, when your award was declared?
31st March 2015 from their report.
Page number 14. Page number 14.
Yes, ma'am. Page 14.
Report, their report.
Yes. Previous page, my lord, your lordship will find. Page 13, your lordship will find the date of declaration of award after 31st/12/2014. My lord, got it?
Where from will get that?
Page 13, my lord, your lordship will find page 13.
13 of?
The report. Report filed by the state.
Page 13 is the affidavit. Page 14.
No, 14 is a continuation. Report filed by the state.
Oh, state. I'm sorry. Huh. Date of declaration of award is 31st March 2015.
Yes.
Now what this?
Now, my lord, from the question will come up, then what is the actual date for declaration of such award? Because it was mentioned the date of declaration of award is after 31st December 2014. My lord, got it? Page 13 of the state report.
Huh. Date of declaration of award after 31/12/2000.
Yes. Serial number 5. Next page, page 40, serial number 5 is Litla.
Yes, Mr. Rai.
So, what is the sine qua non for adjudication of the determination of the benefit? Date of the award.
So you come under the
First
first
clause
portion
itself.
of the disjunctive clause.
After that, or it is not and, or. Now, can you consider or where such award has been announced?
You said you do not come under this purview.
I'm
You
not.
come under the previous one.
I'm also countering their argument which they have advanced before your lordship in succeeding that majority of the landholding. Or where such. Well,
I try to understand my question. You say that so far as the award in respect of ITLA is concerned, that is admittedly after 31st December 2024. Now, both of you are placing reliance upon the relevant notification, which says that all cases land acquisition where the award had not been announced under section 3G of the NH Act till 31/12/2014, or where such award has been announced but compensation has not been paid in respect of major. Now, Mr. I try to understand my question. According to you, come under which one?
First clause.
First clause.
So my adjudication was made on the basis of hypothetically second clause.
What is your answer, madam, in this regard?
My lord, regarding this clause in cases of land acquisition, my lord,
You just compare page number 13 of the report of the state and
my lord, can I
you
lordship my and answer with my in my report, my lord, through my report? Because lordship, I have already mentioned the entire things in my report also.
Very good. Show me. Page number 13 verses 364.
Yes, my lord.
Why you will not come up? Why you will not get
My
the
lord, the acquisition, entire acquisition, my lord, the first line is mentioned the land acquisition. The acquisition means.
Come to 364.
Yes, my lord, 360? 4, my lord. I am in 364 page.
Read clause A.
All cases of land acquisition, my lord. The land acquisition means the entire land acquisition.
Read the
where the award had not been announced under section 3G of the NH Act till 31st December 2014.
Now come to page number 13.
Page?
13 of the report of the state.
My lord, that report is not with me, my lord. No, that is with me.
Very good. Then tell me, in respect of the writ petition, when the award was passed.
My lord, in respect to lordship, the award has been passed, lordship, in different Moses, different dates, my lord. My lord, in case of the ITLA, my lord, that has been mentioned, lordship, after the payment has been made, lordship, on 7th May 2015. That is, lordship, that has been mentioned. And in their report, lordship, has been mentioned the date of the award.
No. So far as the date of declaration of award is concerned, that is on 31st December 2014. Whether he will come under this clause
No,
or
my
not.
lord, he is not come. Lordship, the entire things, my lord, my submission is, lordship, the word land acquisition, the very first land is mentioned, the land acquisition. The lordship, the land acquisition means the entire Mausa. It is not concerned about the Itla Mausa. Lordship, out of the 78 Mausa, my lord, another, including my learned friends Mausa, another 26 Mausas, the compensation has been paid after 31st December 2014. That does not mean that these 27 Mausas are entitled for these compensations. Because the word majority is there, my lord.
Your argument was that the writ petitioner was not entitled to get compensation since in respect of majority of the landholding under acquisition.
Yes, my lord, this acquisition, what is there?
Compensation has been paid as on 31st December 2014.
Yes.
Rather prior to 2014.
Yes.
Now, okay. But here it is a disjunctive clause. All cases of land acquisition where the award had not been announced under section 3G of the NI Act till 31/12/2014. How do you counter that?
My lord, my submission is, my lord, all cases of land acquisition. My lord, this land acquisition cannot be counted in segregated way. This land acquisition means the entire Mausa. Entire 78 Mausas, my lord. My learned friend only harping about his own Mausa, Itla Mausa. My lord, it cannot be this Mausa.
Then why the words in respect of majority of the land acquisition under acquisition has not been used prior to the word or prior to the letters or?
My lord, here, lordship, another clause has been mentioned in C. Because it's C mentioned in cases where the process of acquisition of land stood complete. Of the land stood completed, that is, award under section 3G announced by Kala, amount deposited by the acquiring agency with the Kala, and compensation paid to the landowners in respect of the majority of the land under acquisition as on or before 31st December, the process would be deemed to have been completed and settled, and such case would
Then
not be reopened.
in that case also, the award was passed after 31st December 2024.
Yes, my lord, the word majority vote, my lord, the word, my lord, kindly allow me, my lord, only one thing, my lord, before my report, lordship, kindly come to again, my lord, page 33 of my report, that has been mentioned in the first portion, my lord, in my report, my lord.
Yes. Yes.
The list of Mausa acquired under the NH Act, my lord, the entire list, the list of Mausas, well, page 33. The list of Mausas acquired under NH Act 1956 for four-laning of NH 34 in respect of the district of Nodia, wide notification 3A, and published in the Gazette notification. My lord, this 3A and 3D notification disclose the entire acquisition, this entire 78 Mausas, where it has been clearly mentioned the total acquisition of this land, this 3A and 3D notification. It is an admitted fact. Hopefully, my learned friend is not contradict with my submissions that the 3A and 3D means the acquisition. The 3A and 3D entirely disclose the acquisition part.
Very good. Take down.
Only one thing my lord was asked.
Sir, no.
What is the date of the award?
Sir, please listen to my order.
So, but this Moses is concerned. That is on 31st March.
My learned friend, after submission, all these things regarding the
instant equity সাবধানে টাইপ করবেন, এক একটা লাইন কিন্তু, প্রত্যেকটা লাইন কিন্তু ভেরি ইম্পর্টেন্ট।
পাইলট আমার বইটা একটু
মাইলট আমার বইটা ভালো বলে মাইলট আমার